Let's talk about child support today. When an employer receives a garnishment order from a court or government agency, they are required to comply with that order to withhold and remit the amount demanded. While preparing to comply, the employer should do the following. Tell the employee about the garnishment order to make sure that the employee has received a notice and has had a chance to object to the issuer of that order. Tell the employee about any exemptions that might apply under state or federal law. Tell the employee how the garnishment will affect his or her wages and net pay. If the employee is already subject to one or more garnishment orders, determine their order of priority and how the available disposable earnings must be allocated. And contact legal counsel or your Payroll Service Bureau's CPA to review the garnishment order and answer any questions regarding validity, disposable earnings determinations, complying with out-of-state orders, priorities, allocation, and so on. Child support is the most common of all involuntary deductions. The court order should tell you how much to withhold. You must continue to withhold until the court tells you to stop. While the court order may be clear on the stated amount, there are limitations on how much you can withhold. The Consumer Credit Protection Act provides that the maximum amount you can withhold is 50% of the employee's disposable earnings if the employee is supporting another spouse and or children, and 60% if the employee is not supporting another spouse and or children. These amounts increase to 55 and 65% if the employee is more than 12 weeks behind in making support payments. Some state child support withholding laws may set lower percentages on amounts, but cannot exceed the percentages set by the CCPA. Some definitions. Disposable earnings. Subtract all deductions required by law from gross earnings. These items may include federal, state, and local income tax, FICA and Medicare tax, state unemployment or disability tax, and required state employee retirement system payments. Voluntary deductions such as health and life insurance premiums, union dues, and retirement plan contributions are not subtracted from earnings to calculate disposable earnings, though some states do allow health insurance premiums. Tips. Tips given directly to employees by customers are not considered earnings for the purpose of determining disposable earnings, whereas service charges added to the bill that are later given to the employee by the employer are earnings. Employers should check the state laws in the states where they operate regarding the inclusion of tips as earnings. Priority of orders. If the employer has other withholding orders in place, or you receive other orders while withholding for child support, you need to consult with an expert or your Payroll Service Bureau CPA on the priority of those orders and what amounts should be withheld for which order. Enforcement of orders from other states. Under UIFSA Section 501, an employer must put into effect a child support withholding order that it receives directly from another state's child support enforcement agency, if the order appears regular on its face. Registration of the order in the state where the employee works is not required. Remittance. The employer must send the amount of child support withheld to the appropriate party within 7 business days of payday. Some states actually set a shorter period. Firing. Employers are prohibited from firing, disciplining, or discriminating against an employee because of a child support order. Violators may be fined under state law. Fees. Employers may charge the employee an administrative fee for processing the wage withholding order each pay period. The maximum is set by state law, and the fee must be withheld from the employee's other wages, not the child support payment. Quits. If an employee with a child support withholding order in effect quits, the employer has to notify the child support enforcement agency. Penalties, and this is the big kicker. If the employer fails to properly withhold the amount required, then the employer may be responsible for all unwithheld child support and fines set by the state.